Hello and welcome everybody. I feel like people may still be popping in, but I think it's a good moment to start and to welcome you to this webinar of the Cyber Policy Center at Stanford, where today we're going to talk about the Digital Services Act and the Digital Market Act, which deals with the responsibilities and power of platforms and gatekeepers. These are two sort of twin regulations that are on the table in Brussels right now. For those of you who don't know me, my name is Marietje Schaake. I'm the International Policy Director at the Cyber Policy Center, but also a former member of the European Parliament. So it feels really nice to bridge the transatlantic gap a little bit in talking about technology policies, and to do so with such a distinguished panel of speakers and to welcome so many of you. I'll get back to who we have to address the Digital Market Act and the Digital Services Act in a little bit. Just to step back for a moment, because looking at the last year roughly, between the start of the COVID pandemic, which led to many more decisive interventions by tech platforms, as well as the recent, very troubling January 6th storming of the Capitol, and then the banning of Trump's accounts on several tech platforms, we have really seen an amount of policy decisions, interventions by tech platforms that I think for many of us seemed unimaginable for even decades. Disinformation has been removed. Users have been redirected to so-called trusted sources. Information has been demoted. There's a lively discussion now about what kind of power is appropriate for these platforms, whether we can move from protecting freedom of expression online to considering other rights and how they should be weighed against each other. What role the business models play in amplifying information, and basically what the parameters should be for governing this vastly important online space. Now, concerns over the power of private platforms in governing the digital world have, I guess, been stronger for a while in Europe, where privacy protection is a fundamental right. And you may have heard about the General Data Protection Regulation, a landmark regulation to put standards in place about how data should be protected, and which had a ripple effect all over the world. You may have also heard comments by Chancellor Merkel, who was not very supportive of the takedown of President Trump's accounts. And people were surprised because they said, we've heard so much criticism from Europe about the role of platforms, and now they intervene and you're still not happy. Well, I think what we can discern from these comments is that it is actually the power of big companies that concerns many in Europe. And it doesn't essentially matter how they use that power. The power itself is the concern, but we can talk about that more. In any case, during the last years, also during the Trump presidency, there's been a lot of thinking and work being done in the European Union to ensure that democracy is resilient in light of digitization, but also to regulate for many aspects of digitization, from AI to data governance, the anchoring of digital freedoms. It's been a process that's been steadily moving along with quite a few initiatives. And the most outstanding are the twin regulations proposed late last year, the Digital Services Act and the Digital Market Act, which would be quite far-reaching in clarifying the responsibilities, the liabilities, and the role within the ecosystem that different platforms and gatekeeper companies play. These two proposals are said to build on existing law, whether it's about speech or liability and their exemptions, sector-specific rules, for example, about terrorist content or antitrust, copyright protection. You will see a lot of familiar elements coming together here in a specification about what the responsibility of companies are, and also how this should apply proportionately. So heavier responsibilities to bigger companies, fewer to smaller companies, as well as a harmonization between different member states of the European Union, which is an element that may not always be appreciated looking from the US side, is how much the 27 different member states of the EU still have different rules and different applications of rules, and how the EU often takes the initiative to try to harmonize those somewhat. The Digital Services Act would be a horizontal legislation dealing with all kinds of content, but also civil and criminal liability. As I mentioned, it seeks to be proportionate to the size of companies, but it also means that looking at the whole ecosystem, one company could be, considered an intermediary service in one context, but also be responsible for moderating content. So it could be a different actor, basically, depending on which moment or which interaction is being zoomed in on. The threshold at the moment for big scale lies at 10% of the EU population. So that would mean 45 million EU-based users. And it also includes the question of marketplaces and social media, where the lines are increasingly blurring. So it's not just about social media platforms, but also what they call collaborative economy spaces and app stores. This proposal goes beyond market regulation and economic interest, but also seeks to address societal harms and builds on the fundamental rights protection we know in Europe. So I think there's a lot that we can pick apart in the various aspects of this far-reaching set of regulations. I'm very happy that we have with us today Joris van Hoboken, who is professor of law at the Vrije University in Brussels and also affiliated with the Institute for Information Law at the University of Amsterdam. Also welcoming our own Daphne Keller, who directs the program on platform regulation with us at the Cyber Policy Center and has experience working in the private sector. She was Assistant General Counsel at Google in the past. Then we welcome Eliška Pírková, who is Access Now's Europe Policy Analyst. And in the interest of transparency, I should note that I serve on the board of Access. And last but not least, Guillermo Beltrà joins us from the Open Society European Policy Institute, where he is the digital policy lead. After their brief introductions, we will have enough time for your questions and answers, so please pose them in the Q&A function. This meeting is being recorded, so if you want to share it later with your colleagues or people in your network, you can. It will be on YouTube and you can access it through our website. And what might also be good to know as you're listening to our experts is that this is still a proposal on the table. It is introduced by the European Commission, but it still has to go through the European Parliament and get agreement from the EU member states. So this is very much a lively set of regulations on the table. They are not set in stone and they are not applicable law as of yet. And we expect heavy lobbying. So this is your chance to be informed and to see which direction you would like to see these twin proposals going into. With that, sorry for the long introduction. Joris, the floor is yours.
Thank you so much, and thank you so much for the invitation to be on this wonderful panel. So I wanted to also set the stage a bit for what we're looking at in terms of the proposals on the European side. It's obvious that we are seeing a very ambitious new regulatory agenda for digital services being launched here by Europe. I just want to mention, I mean, we have spoken a lot in the last year, like in anticipation of the Digital Services Act. The Digital Services Act plans ultimately got kind of, split into the Digital Services Act and the Digital Markets Act, which looks more at economic gatekeeping power issues. But there's, there are other parts of this too at the moment that are moving. There's the Democracy Action Plan, with particular relevance also for the discussions around disinformation. There is quite ambitious proposals on the table for data governance and data spaces that have to be created. And also quite some moving parts in the consumer protection space and really adopting consumer law to the digital age. Those frameworks are also still in development and moving forward. I want to focus mostly on the DSA part. Really, first, maybe what is behind it? What is really the main? What is really one of the main drivers of this? I think there are a few of them that we can mention. I think first of all is platform power. And really the significant impact that digital services and dominant platforms in particular are having on our society, and also then connected to that, their responsibility for dealing with certain issues, that like are facilitated by the platforms, in particular illegal but also harmful content online. We're coming in Europe from a situation where we had a liability responsibility framework for intermediaries that was adopted in 2000, the famous e-commerce directive. And that really the basic parts of that were not changed for a long time now, for 21 years. But there is a lot of movement on the side. There's various developments in what people call verticals, with respect to child sexual abuse material, with copyright, and now recently terrorism content. But now finally we see, this proposal on the table to extend, the e-commerce regulation. And then a second point there I would make is that we're really, what we're seeing is that we're moving from a regulatory framework in Europe where self-regulation was a really big component of that framework to a place where things are much more kind of solidly regulated by government, by state regulation. And that is something that is a significant change. We have seen a lot of self-regulatory developments over the last decades, and also a lot of soft law. The European Commission already had, guidelines on legal content and how to deal with that. But now we really see the Digital Services Act picking up on a lot of that, and moving it really into giving it a more solid regulatory footing, and on top of that, creating mechanisms and proposing mechanisms for different forms of oversight, like to give the rules a certain amount of teeth. So I want to keep it very short, but I want to just quickly also say something about the main ingredients. So liability, which was really at the core for intermediaries in the e-commerce directive, is part of the DSA, and is to something of a surprise to me, is left relatively unchanged. So the safe harbors that were adopted in the e-commerce directive, and that actually there was a lot of discussion where they were really still fit for purpose. And I did a little bit of writing about that myself, that maybe there are some really good questions to be asked about, if they could be improved. They're left relatively unchanged. So what is happening is that part is still on the table, but then we see a lot of new rules that basically are about all sorts of like new responsibilities, all sorts of standards, and all sorts of like expectations to do a certain amount of risk management. A second part, and I just mentioned that, is proposals to create oversight. I think it's very significant. The e-commerce directive didn't have a system of oversight attached to it, and I think that that had some downsides that showed. So the DSA has that. Then a part which is significant and has a lot of discussion, seen a lot of discussion also from the academic side, is access to data. Access to data about, what is happening on platforms, and, how can we get the data that helps us to understand the dynamics on platforms, and then also on the basis of that to understand the impact that platform and platform dynamics have on our society. And finally, this was mentioned already by Marietje, we see this tiered system being proposed, with heavier duties and responsibilities for the larger platforms. Just some final points here, like the DSA and DMA, they're very broad frameworks, so they're really not the DSA, even though maybe a lot of the social media type of dynamics will be really front and center in the discussions and in the political debates, it goes far beyond that, and it's really it also applies to more economic market actors, and that I think is very significant, because in the way I think I see coming is that the dynamics also between the member states and the European level is quite different with respect to social media and between market platforms. I see, in the social media space, I see a chance for the member states having actually a significant interest in creating their own kind of dynamics with, this new emergent platform power, where for economic platforms, I expect that there's much more willingness to let Europe lead on this. I'm going to stop here and pass it on to the following speakers.
Thanks, Joris. Over to you, Daphne.
Thanks so much. So there's a remarkable amount of expertise gathered here, both on this panel and in this audience. So I'll try to keep this brief so we can all talk to each other. Marietje asked me to speak both about what's going on in the EU and in the US. And I would start that by saying that Americans are relative amateurs when it comes to platform regulation. We've seen a lot of proposed legislative changes in the past year, but Congress is really kind of throwing spaghetti at the wall and making things up. I recently published an op-ed in The Hill on this topic, which was basically a love letter to EU civil servants, saying that Congress should emulate the DSA in a couple of key respects. One is to identify what issues are privacy issues and use privacy laws, create privacy laws if need be, identify what are competition laws and use competition laws, and not mix together privacy and competition issues with the often separate issues that arise from speech regulation, which are the kinds of issues that are targeted by the DSA and that are covered by Communications Decency Act Section 230, the notorious CDA 230 in the US. Also, I think the DSA sets a model that the US should follow in treating companies of different sizes differently and treating companies that play different technical roles on the internet differently, particularly when it comes to infrastructure providers. And then finally, I think the DSA sets a very good model in not just saying, hey, platforms, here's a problem, make it go away, we don't care how, but instead being realistic about how content moderation works in the real world, how abusive notices can cause platforms to silence important voices, to silence marginalized communities, and how specific processes or public adjudication by regulators or judges can help correct for that problem. At the same time, I think there are big areas of difference where US legislation isn't going to go in the direction of the DSA, and we should be practical about those also. There are two big ones I would focus on here. The first is just an underlying difference because of US First Amendment law in which kinds of online speech lawmakers even have the power to regulate in the first place. There is a lot more lawful but awful speech that is constitutionally protected in the US that would be unlawful, criminally or civilly unlawful in lots of other parts of the world, including things like hate speech. So I think while there are a lot of US lawmakers that actually would like to regulate the same speech that European lawmakers are able to, their hands are tied, for better or for worse, because of the First Amendment. And that leads to an unfortunate situation where Congress sort of resorts to laws that are not requiring platforms to do overzealous takedowns or overzealous compared to the First Amendment takedowns, but nudging them to do so in various ways without quite admitting that that's what they're doing. And that is a really undemocratic outcome. It avoids democratic accountability, public oversight, constitutional checks, but we're getting there because of this problem with Congress not being able to regulate speech that a whole lot of Americans are demanding should come down from platforms. The other area where I see a real difference between European and US approaches is in the politically acceptable trade-offs between competition on the one hand and regulation of platforms, particularly content regulation on the other. There's a US version of this that's just kind of generically super pro-free markets that, I think will prevent the creation ever of the kind of extensive regulatory infrastructure that the DSA contemplates. Like, I think the US is not going to land in a place where we have the kinds of audits and risk assessments and so forth in place that the DSA contemplates. But, you know, as someone who isn't in that super duper pro free markets camp and who sometimes envies Europeans' capacity to regulate in other areas, I do think here, you know, despite the size cutoffs in the DSA, I'm quite concerned that it effectively will entrench incumbents, you know, that it sets rules that small and growing companies won't be able to comply with, or won't be able to find investors to support them complying with, and will increase their incentives to just be acquired by the incumbents, and ultimately sort of entrench incumbents and sacrifice competition goals in online platforms for the sake of content regulation goals. Turning to the US and turning to specific legislation in the US, I'm just going to blitz through this so that I don't eat up too much more time. But we have a split where many Democrats want platforms to take down more content. Many Republicans want them to take down less content. Both of those come out of positions I think many of us can sympathize with, including the concern about major US companies being gatekeepers for online speech and discourse. But that leads to a lot of legislative proposals that are unlikely to get bipartisan supports. That makes it hard to predict which mandates are likely to actually be able to move forward as legislative amendments. But my guess would be either those that are targeting universally reviled speech, like child sexual abuse material or content, or those that, like the DSA, have some focus on process, on transparency of rules, on appeals for users, things of that sort. And I will, with that, hand off to the next speaker.
Thank you, Daphne. So much more to talk about, but indeed, hopefully time for that during the Q&A. Eliška, over to you next.
Thank you very much. And again, it's a great pleasure to be here. I will start maybe with a sort of introduction, what civil societies have been up to and how this whole entire work on the DSA file actually took off. Even though the law was launched already on 15th of December 2020, so not such a long time ago, there was quite some time of preparation and thinking through in terms of our positionings, meaning civil societies that actually operate in Brussels, but not only those that are directly being based in Brussels, but those who actually have digital rights as the primary agenda of their work. It was a big priority for us from the beginning, and already based on Access Now previous positioning on this topic, we've always been convinced to a large extent that state regulation that is being done right, where human rights of online users or individuals are actually being in the core and in the center, together with other user-centric measures that will return agency control and empowerment back to users. And that's not only the goal of DSA, but partially of DMA, the Digital Market Act that has already been mentioned at the beginning, can achieve in one way or another. We believe that state regulation have its deserved place if we want to achieve that level of content governance that we are hoping for. So at the beginning, when DSA was announced, we first worked with just a group of leaks and documents that were actually leaked through press until we finally started receiving the official documents from the European Commission. So this is just to underline how long process of preparation went into this legislation. And this is just the proposal, and we are very much at the beginning of our journey. And so the first main reaction we had when we finally saw the draft was actually rather positive. We have to realize that the European Commission was tasked with incredible goal to actually draft the law that will cover many different aspects, from harmonized notice and action procedure to appropriate enforcement mechanism. Because as we learned also from the GDPR experience, if the enforcement mechanism is not functioning well, the law can be perfect on the paper, but it still misses its mark. And we are still actually going through the law and unpacking each section and going step by step, because this is really a monstrous legal proposal, and devil is always in the details. But to say and describe the first impression that we had was rather positive. So DSA is definitely a good start for that platform governance or that model of platform governance that we envisioned. But of course, it still contains a lot of imperfect solutions. And the following years that will unfold, and now with the DSA entering the European Parliament, there will be a lot of work and hopefully a lot of space for further improvements. Now, before I will actually touch upon those main positives and negatives that we see within the draft and perhaps our hopes for the future, I just would like to maybe clarify one more information on the procedural part. In summer 2020, European Commission opened a consultation on DSA, which was a very extensive consultation consisting of a questionnaire that contained 270 questions that were quite extensive and of a very technical nature. And as a result of that consultation, the European Commission received around 2,863 responses. And from those, around 300 position papers that were actually drafted by civil society sector. That is quite a lot, but in contrast to that, many other positions and lobbying activities that were also actually imposed by and conducted by the private actors, it is still quite little. So just to bring a little bit of Brussels context into this debate. But overall, we are very happy how European Commission managed to be receptive of our ideas, and many of those are actually being reflected in this draft. So now I will just quickly touch on the main positives that we've seen within the draft, such as the preservance of the conditional model of intermediary liability, which is quite still under Article 14 of E-Commerce Directive for those who are a little bit more familiar with the European legal framework, which is relatively and quite different from the one in the United States. And we also achieved a model or an effort to harmonize the notice and action procedure, even though there are quite a few shortcomings and not everything has been made and proposed in a way that we hoped for, but I got to that in a minute. There is also a prohibition of general monitoring that was a huge priority for us from the very start. And if anyone is interested in further details about our positioning, I believe that the link to our position papers will be shared with you, and we of course assess the draft against that position that we've been developing. We were also very happy with seeing improved transparency requirements. Now I know that transparency is being mentioned a lot, how much we need meaningful transparency that will be user-centric and transparency that will also serve for the purpose of public oversight. Data access framework, which is one of those biggest enablers of such a model of transparency, has already been mentioned by Joris. But we still think that the list of transparency requirements that is currently in the law could be improved and could be even more ambitious. And maybe here it's also important to mention that DSA specifically distinguishes between online platforms and then very large online platforms, and again, places another separate set of those transparency requirements on very large online platforms. And finally, we were also at least partially welcoming the enforcement mechanism that DSA is currently proposing, even though there is still a big question mark about how that enforcement mechanism will work in practice and whether we truly learned our lesson from GDPR. When I say that we are welcoming that model to some extent, we were big defenders of the decentralized model of enforcement of DSA at the national level due to the large scope of the law that we have already foreseen at the very beginning. We started actually working on our positioning and on this legislative proposal. And of course, our main priority is individuals and their fundamental rights. And we wanted to make sure that actually the access to effective remedy and appeal mechanisms will be granted, which DSA also delivered to quite large extent, proposing several different mechanisms how to actually access such an effective remedy and let their voices to be heard and to really challenge the decision-making processes of platforms. But also due to that scope, we need to guarantee that public regulators will be able to effectively oversight that part of DSA that actually falls into their scope. And DSA very much touches also upon issues of data protection. And I go towards that now. So this is just the summary of the positives, the DSA in our view, or at least it's a good start when it comes to these concrete measures that I mentioned. Of course, there is more. But probably one of the biggest weak spots of DSA for us so far is still that vast amount of competencies and powers that are being left in hands of online platforms who are ultimately private actors. So that goes for instance, assessment of the legality of user-generated content. So what actually amounts to illegal content and what is another category of content that potentially might have violated terms of service of companies, but doesn't necessarily violate the law. That all remains in hands of online platforms. This is, of course, for us quite a big problem due to the fact that we know that platforms often assess the content in very non-transparent manner with no public scrutiny, and it's not always, or it's not really clear on what criteria the content is actually being assessed. We would also welcome probably more procedural safeguards, especially when it comes to procedural fairness. So even though the DSA does create the possibility for counter notification, for instance, that means if a content provider wants to challenge the decision of platforms about content removal or restriction of that content, they can do so. But for us, a big topic was actually to issue a notification to users prior any action is being taken about that particular content. Of course, there are then exceptions from that view that should be also taken into consideration. However, there are some measures that we were hoping for to see within the DSA, and unfortunately, at least for now, they're not there. The DSA also touches upon the issues such as terms of service, where we believe the proposal could be much more granular. In that regard, we know that we currently suffer from both. On one hand, it's the lack of standardization of terms of service. So that means how actually individual companies interpret and apply their internal use. And on the other hand, we could even speak about too much of that standardization, because we also know that there are a few global dominant platforms that within the European Union, we sometimes refer to those as online gatekeepers, which is the term that is used mainly by Digital Market Act. And Digital Market Act also provides for a definition of who can become a gatekeeper or who fulfills those criteria.
Eliška, sorry, I'm going to encourage you to wrap up because there's so much to say, but otherwise there's no time for the guests. So we can maybe keep the rest for the Q&A.
Sorry, this is the issue with DSA. There is just so much to unpack that it's quite difficult to know where to step. So I'll step for now, and I look forward to your questions.
Thank you. Guillermo.
Thank you, Marietje, for having us, and good evening to all of you, and good morning for all of those who are in the West Coast. The Open Society European Policy Institute is part of the Open Society Foundation's network. We're the EU-based policy and advocacy hub. And we're closely following these two proposals. And at OSF, we come at this debate from two main angles. The first one is that we want to strengthen the resilience of the digital public sphere. These platforms that we're talking about today, the big ones, have become the operating systems of our democracies. And they permeate so much of our lives that many harms that Marietje was signaling at the beginning, from the widespread presence of surveillance-based business models, the lack of accountability of these platforms, the amplification of disinformation and hate speech, the consolidation of power of some of these big companies, and the erosion of cornerstone institutions in our democracies, such as journalism and free and fair elections, are all at risk today. And so for us, the EU has done absolutely the right thing to dedicate a lot of political capital, resources, and attention into how it can upgrade its rules to precisely address all of these harms. The second angle that we care in a very particular way at OSF is that these harms are unequally distributed. They disproportionately affect vulnerable and racialized communities the most, and especially those in the geographies that we're not talking about today, so beyond the EU and the US. And so it's very important that as we debate all of these new rules and how they impact in the world, we take a global perspective about it. Now, like the previous speakers have said, these are monster proposals, and the devil is definitely in the details, so we're analyzing them as well. But just here a few impressions from us. On the DSA, I think it's important to bear in mind where we come from politically as well. Over the past few years, there have been not few political voices asking for a complete revamp of what was before the e-commerce directive. Principles or regimes such as the intermediary liability regime, we should not take it for granted that they were going to stay. And the fact that the European Commission has said we're sticking to the idea that we are going to create a system of rules that promotes and protects free speech online, I think it's a very positive and welcome development. Now, of course, the idea, like Marietje, you also flagged in the beginning, is that 20 years ago, the e-commerce directive was a purely market regulation. The idea was to harmonize rules so that it would be easy for companies to enter the EU and offer their services across 27 member states. Now, that is still in the DSA, but it has widened its horizons a lot. And now at the very core of the DSA, at the very beginning, it says the objective is also to protect fundamental rights. And that is a super welcome element that we obviously agree with. And then further deeper into the DSA, and I'm sure we'll talk about this, some of the colleagues have mentioned it as well. It creates a regime of so-called systemic risks for very large online platforms, where they have to then bear in mind other public policy objectives, from public health to civic discourse and the integrity of elections. So the DSA, in essence, does look into, it has a holistic and broader perspective into how do these platforms affect the collectivity of issues that represent a democracy. So on paper, at least in theory, that is a good starting point. And we look forward to working with the EU co-legislators in improving the details, and experts like Eliška, Joris, and Daphne, I'm sure, will be providing a lot of insight into how to tweak a lot of the details in there. Now, on the Digital Markets Act, on the other hand, well, first of all, we believe it's a very good idea to have additional regulation that looks to where has the power been concentrated on the internet, so much so that just by market processes, it is very hard for all of these harms to go away. And so what the Commission has rightly recognized is that ex post competition enforcement is not enough. Over the past few years, the European Commission has had a very ambitious competition enforcement agenda, but still it's been too slow, not ambitious enough, and the key actors have barely moved in their main practices. So adding to the EU's rule book some additional rules to address this gatekeeping power is definitely a welcome initiative as well. The problem is that on the DMA, the European Commission has backtracked on its initial ambition, and that is not so good. Because initially, from leaked documents and from the Commission's own announcements, it was going to do a much bigger reform, so that it would give itself additional powers to be able to act more quickly into markets without having to go through the entire process that ex post competition enforcement entails. There are positive elements in the DMA. It has a short period before it enters into law. It has a powerful system of fines. There are behavioral and structural remedies, but there are also a few weak spots. It's going to be hard for the Commission to use those powers if the law stays the same way. And the prohibitions of what these so-called gatekeepers cannot do are not as ambitious as they should be. There are interesting proposals, such as, for example, on interoperability that we're looking into more detail with, and there are many actors in civil society that are looking into that as well. So in addition to perfecting the DSA and strengthening the DMA, the other important exercise that we hope to encourage the EU co-legislators to do is to bring in the global perspective into this policy process. We need to make sure that as the debate moves on, we have a truly inclusive and open process so that representatives from civil society and communities from around the world can come and tell their story to the EU co-legislators, because it is very likely, and we're already seeing some evidence of that, the world is watching, and many other jurisdictions will look to the EU as to how they prepare these rules. I look forward to the conversation. Thanks a lot.
Thank you, Guillermo, and thanks everyone. Clearly there's a lot to be said, and I at one point worried that this would go into a lot of detail because all of our speakers are such experts, but then I looked at the Q&A and saw such detailed questions that I think we're okay. I will start with a few slightly more general questions to set the tone and then go in more and more detail. So one question is from William Patterson, who asks, to what extent might the no longer applicable US broadcast fairness doctrine provide guidance on the responsibilities of platforms, a monopolistic or oligopolistic market structure? And I will ask Daphne to answer that.
Yeah, so this is a recurring conversation in the US. I actually was on a long and very expert and interesting Twitter thread about it, I think yesterday or the day before, if anyone wants to dig up a back and forth. But basically, the fairness doctrine was justified as a constitutional matter, in Supreme Court cases, by the scarcity of broadcast spectrum, the idea that it makes sense for regulators to come in and require sort of private gatekeepers of public discourse to set fair rules, because there aren't enough channels for everyone to speak. The Supreme Court rejected an analogy to that for the internet in the seminal First Amendment internet case, Reno v. ACLU, 20 years ago. And so while there is a lot of discussion about is there a different way to argue this that might lead Congress to be able to enact a rule like that or the Supreme Court to uphold one, it's all very speculative, and the case law is not in its favor. The other problem is a lot of critics, particularly from a more sort of libertarian perspective, say, hey, wait a minute, the fairness doctrine was a mess. It was something that enabled the party in power to put its thumb on the scales and shape public discourse in ways that were actually really problematic. And this is sort of a fight about the historical narrative of what actually happened. And then for what it would mean for platforms, does it mean that everyone who disagrees about a Facebook content moderation decision gets to have an avenue of appeal to regulators? How much do you staff up the FTC or the FCC to handle something like that? Frankly, that sounds impossible. And what does it look like if it's not avenues of appeal? So it gets very complicated very fast. But I think it is in a very big, high-level way, the right thing to be talking about, if only because telecommunications law and media regulation are the history of how policymakers thought about the intersection of speech and competition issues. And so there are real insights from the cases and scholarship and legislation of that age that we should be thinking about now. And it's explicitly relevant in Europe because of the Audiovisual Media Services Directive and other legal instruments that directly draw on the history of media regulation.
Thank you, Daphne. Now to Joris. I'm going to merge two questions. One from an anonymous attendee who asks, Articles 8 and 9 of the DSA mention national authorities that can request information or require takedown. Are this the digital services coordinators? And if not, how are the powers divided between the different authorities? And on top of that question, Karen Melchior, a member of European Parliament, asked, what is a term, an amount of time that we might expect for illegal content to be taken down? There's been speculation about 24 hours, 7 days, but it turns out that many legal authorities take longer. So, Joris, can you add that to the question of which national authorities?
Yeah, so what we see, if in fact, is that, and maybe in my answer I will just build on a recent study we did in the Netherlands that looked at removal of unlawful content, including illegal, but could be privacy infringements, could be all sorts of things that are legally impermissible to be published. But then once it's there, it's how do you take it down? And the question is, what procedures are available for that? And when you start looking at that, at the legal landscape, it's really quite diverse. We have administrative law procedures that can be relevant, in particular also if things are involve publication of personal data. We have the data protection authorities getting involved. We have roles to play for consumer protection authorities in particular areas. We have, of course, law enforcement playing a potential role. And so it is really quite diverse, and like this is also going to be different from member states to member states. It's not that Europe is going to come in and like harmonize this across Europe. So typically you see a relative amount of flexibility on the frameworks for this that are being set up at the European level. So the challenge, of course, with this is that we are basically seeing all these different authorities dealing with these kind of emergent, very central, kind of powerful platform actors, and having to develop expertise and knowledge, to engage with these actors very effectively. And that is, I think, that is one of the major regulatory challenges, and also of our time. How can we really update our current legal systems and institutions to a world where power has shifted in many ways? So I understand. I'm not giving a very technical answer, but like trying to give an answer to speak to the challenge of designing the proper kind of regulatory authorities to take up these tasks. In terms of like the timing, I've always like argued against these very particular time frames. I don't think they're very sensible. I think it is a way for political proposals to make the headlines. It's an ideal headline, like you'll get like this now, like the orders, it has to be taken down within an hour, within 24 hours. It works really well. And if the law says expeditiously, everybody's like, what does it mean? But these are, I think, lawmaking is this type of law and legal design is better, like to leave some flexibility to the situation. I don't think we should try to turn platforms into courts at all. I don't think we have any good, academic work, like proposing that, this would be a good idea. I've never seen really good proposals for why we want to do that. So I don't think the comparison between our like legal authorities and the authorities or like the platforms makes a lot of sense. I would actually say they're exactly, platforms. Obviously, if you're a platform and there's stuff happening that shouldn't be happening there, or you didn't permit it, or it's doing people harm, you should have procedures that are relatively accessible for your users and for people affected. When things don't go well in our society, really in a way that it really doesn't go well for people, like ultimately you want access to the court, access to justice, especially when fundamental rights are at stake. But these are much more selective procedures that have much higher thresholds also for people to get access to. We have like a lot of literature on access to justice. Like it's not very easy to design legal systems, that do a good job at that. So I think that is for me the way to look at that. I think platforms have a big role to play there and have like accessible procedures for these types of issues, and the courts have their own role to play and are an important safety net.
Thank you. Guillermo, I'm going to join two questions together for you. One, what will be, Simon Hanya asks, what will be the geographic scope of the DSA, particularly when taking down content, the EU, worldwide? And he's recalling the right to be forgotten discussion in that context. And then adding to that, and please just answer briefly if possible, Laura Bartley asks, what improvements or modifications should be made in relation to the risk assessment and auditing process to make it more robust and transparent? Is it with more trusted flaggers that are included just beyond flagging illegal content? Thanks.
Thank you. So on the geographical scope, both the DSA and the DMA actually contain a provision that says that any company that provides one of the services covered by the scopes of those instruments that target their services at people in the EU would have to comply with that. So in a way, it's a bit like the GDPR extraterritorial scope. There are new provisions that oblige these companies to have legal points of contact inside the EU. But it is a very good question that I had not asked myself yet, I will admit, about how this might interplay with the right to be forgotten and all the jurisprudence in that case. So I don't have a concrete answer to that part of the question. And then in terms of the systemic risks and the auditing by regulators, that is precisely what we need to make sure that the digital services coordinators and the network of that they will be forming by themselves have the solid powers to be able to monitor how these very large online platforms are creating this so-called risk mitigation and risk assessment measures. Right now, trusted flaggers is an additional obligation for more platforms. There are possibility to open to trusted flaggers. There's a lot more to look into to make sure that these regulators have the actual capacity to do that.
Great, thanks. Now to a more detailed question. And I think maybe this should go to Daphne or Joris again, but let's see. Alex asks, referring to section 26b, quote, any negative effects of the exercise of the fundamental rights to respect for privacy and family life, freedom of expression and information, the prohibition of discrimination and the rights of the child, as enshrined in Articles 7, 11, 21, and 24 of the Charter. In other words, the obligation of platforms to assess risk associated with a large amount of factors beyond illegal content strike him as important, possibly including discrimination or harms to children like self-harm or suicidal behavior. Alex also says this strikes me as problematically vague. How should we interpret this section? Is it language to start a conversation with fine-tuning to come, or is this meant to give the European Commission flexibility in the future?
I was gonna highlight that question. Actually, I think it's a really good question and it's a really big part of the regulatory innovation that is happening. European Commission and European Union more generally has a lot of appetite for including risk management type of structures in regulation. We have also seen that with the GDPR. You know, the GDPR in relation to the directive 1995, one of the major innovations was the risk-based approach, and we have these data protection impact assessments that are included. So we see this happening now in the area of illegal content, and I think I'm very positive about the fact that this is quite inclusive. You know, I think that we have freedom of expression, especially mentioned there. This is something that I actually also advocated for myself. It is very significant, but because often when we have these discussions about illegal content, the only number we hear is like how much stuff is taken down. You know, so it's only focused on we have the illegal content, this is illegal, this is very, very bad, so it has to be taken down. And it's kind of this very one-dimensional approach to risk management, but you know, there's a lot of other things at stake, including, you know, especially also freedom of expression. And so I think it's very good. It is indeed very inclusive. It needs to be fleshed out. We do not know how this is going to look in practice. There are some experiences from, you know, I think within the corporate environment, like around corporate social responsibility, and, you know, we have the GNI type of principles. There's quite a lot that can be worked with. You know, but it is not obvious that, I think it is also not obvious that there's one right way to do this. I can see different innovations in the industry with that. And I think there will be a very important conversation also with, you know, the general public and regulators. It's like, how well are you doing this? This is, of course, creating a certain amount of legal uncertainty, but I think that is by design. It is really by design that we see, you know, like, and we have in other areas. I mean, we have the data protection by design article in GDPR. This is like, nobody really knows what it legally exactly means, you know, but it creates like a whole kind of regulatory dynamic, you know, moving forward. And then, you know, in 5-10 years time, you can pick up on that and maybe codify some of those elements that emerge.
I would add, you know, part of the question was, is this problematically vague? Sure, you know, it's demanding balancing between these huge, important competing rights and values like privacy and free expression and the rights of the child. And those will arise in infinite diversity in the future of the internet in different places on different platforms. And so prescribing how to balance those things would be an impossible task for anyone. What maybe is additional power to with the commission in a way that member states might not like, or people who would like this to go to courts might not like. So there's sort of an EU institutional power question here that I think is probably more immediately answerable than a big substantive question about how we balance these rights.
Thank you. So much more to discuss, but we're coming close to an end. I'm going to ask one more question, which was asked anonymously and directed to Eliška, and then do a quick round of final thoughts for everyone. The question is, how does the DSA tackle the issue of proxy servers? Are these players subject to the, and then I see KYBC, but I think it's supposed to say know your customer principle, and to identification of third-party users' obligations?
Hi, thank you very much for that question. Actually, to be honest, this is the part of the DSA that we haven't been really working on that much yet, so I'm not quite sure whether I am the right person to answer this question. Unfortunately, I could actually just add to pretty much everything else what was previously asked, but if you maybe then can refer to this question to someone who is more suited to answer that. Thank you.
Yeah, no problem. Why don't we do a last quick thought in reverse order? So I'll start with Guillermo.
Thank you. Well, first of all, thanks to the other speakers for sharing so much thoughts. There is so much to unpack, and I look forward to working with all of you and a lot of the a lot of names of friends and colleagues that I see on the chat as well. This is a historical time, I think, and there's a lot to be won. Just one last thought on the DMA in particular. As I mentioned before, it's been great that the DSA has sort of widened its horizons of what is the public policy purpose, why do we need this law, to cover fundamental rights and broader societal objectives. The DMA, on the other hand, its guiding principle is very much still market driven. The only rationale for its existence is to address distortions in the market, right? And one of the things that we want to work together with the EU co-legislators is to see within the legal limits of what they can do, see how this instrument can be linked better with the DSA and purposed more consciously towards these societal issues that gatekeepers create. And so if anybody in the audience also works on these issues, we'd be super keen to discuss and brainstorm some ideas. Thanks for having us.
Thank you. Eliška.
Well, I would like to maybe conclude and maybe elaborate a little bit on that. This is actually a legislative package that consists of Digital Services Act, European Democracy Action Plan, other legislation that has already been announced that will be focusing on political ads, and DMA is definitely the part of it. So at the end of this process, what we would like to see is beyond all those requirements on transparency, notice and action enforcement, is actually the internet where users have choice, where they feel empowered, and DMA equally plays the role through already mentioned interoperability and portability of data that our partners, including us, are currently working on. And it's a patchwork that has to come together, and every single part in that patchwork will play an important role. And that goes also for core regulatory principles and other so-called regulatory backstops that we will see happening that also have their pitfalls, such as code of practice on disinformation and other code of practices and code of conducts that the European Commission will be working on. So these are definitely exciting times ahead of us.
Thank you. Daphne.
Yeah, I guess I would wrap up by saying the DSA is going to shape platform power and platform behavior everywhere in the world for decades. And so if you are not a European and think this isn't of interest to you or don't focus on Europe, please rethink that. And in particular for people in the audience who are neither Europeans nor United States citizens or practitioners, your voices are sorely missing. There's a sense that this is a US versus EU question about regulatory approaches, and there are so many other experts in the world and people with important perspectives, and I hope we can find ways to make those voices heard in Brussels as well, because this really will be a global law.
Thank you. Joris, some last thoughts.
Yeah, I think I agree with that, and I think it's important for those in the US to realize that maybe in the US you're kind of the outlier with a relatively dysfunctional regulatory system. I mean, it's very hard to pass new laws in the US political context at the moment, and also I think a situation where you're dealing with companies that have, you know, that their responsiveness towards US society is a little bit more natural than maybe looking at this from a Slovenian or like a Northern Finnish perspective. You know, like, so I think it is important to realize that what is at stake for our societies. For that, I think it's also very important to draw on a wide variety of expertise in the debates. So at the VUB, we set up this seminar series called the DSA in Perspective seminar to get academic voices with expertise on these matters involved in the discussion around the DSA. And at the Institute for Information Law, we are just launching a project called the DSA Observatory, where we're going to have this platform for you know, like for independent you know, analysis on the proposals and what is at stake. So, and both legal expertise, but also other types of expertise about, you know, how platforms are impacting our societies and what would be good ways forward on that.
Thank you so much, Joris. I think, like everybody, this felt like more information than we could squeeze into 1 hour, despite everybody's very, very good attempts. Thank you. I asked in the chat whether people would be up for an ongoing session or a new session to dive deeper into the Digital Services and Digital Markets Act, and I think a lot of people are keen, so we will look at a way to organize that. What we do know for sure is that on February 24th, we will host our next webinar, which will deal with policy recommendations for the Biden administration from a tech policy point of view, with Kelly Bourne, Karen Kornblue, and Michael Daniel. We constantly try to engage different people and experts from all around the world, and look forward to seeing you at one of our seminars again. Tomorrow, we will actually be publishing a set of tech policy recommendations for the new Biden administration from a variety of experts. So if this has your interest, stay tuned, and that might be a relevant piece to reflect on as well. But for now, Daphne, Joris, Eliška, and Guillermo, thank you, as well as David and Michelle behind the scenes for making this possible once again, and for the many participants who joined us today. It was great, and we will continue this discussion.